All right, hello everyone. Thank you for coming. Welcome to our panel, How Should Campuses Handle Sexual Assault Cases? I'd like to briefly introduce our distinguished panelists who will each, after I'm through all the introductions, give a short sort of contextualization of what brings them to this issue and what they're interested in, and then we'll have a conversation and Q&A as is sort of the usual for these events. So first, I'm happy to introduce Suzanne Goldberg to my right at the end of the table, who comes to us from Columbia, a little university up the road, where she's the Executive Vice President for University Life. Herbert and Doris Wexler, I guess I just combined them into Horace, Wexler Clinical Professor of Law, a very distinguished title, and the Director of the Center for Gender and Sexuality Law. She's also currently the Associate Reporter for the American Law Institute's Project on Sexual and Gender-Based Misconduct on Campus, Procedural Frameworks and Analysis. Prior to joining Columbia in 2006, Professor Goldberg taught at Rutgers Law School, and before that she was a senior staff attorney with the Lambda Legal Defense Fund, where she began her career as a Skadden Fellow. For decades, she's focused significantly on family recognition, including the recent marriage cases. She also has done work with employment discrimination, asylum based on sexual orientation, and other gender identity issues, and is the author of many academic articles and op-ed pieces, as well as a co-author of Strangers to the Law, Gay People on Trial. Next to me is Samantha Harris, who is our Director of Policy Research at the Foundation for Individual Rights in Education, known by its acronym FIRE. She's a graduate of Princeton University and the University of Pennsylvania Law School. And in addition to working on campus free speech issues, she writes extensively on the topic of campus due process, particularly in the context of campus sexual assault adjudication. She's spoken to students, faculty, and administrators around the country and has represented FIRE publicly on national television and radio, as well as in publications including Inside Higher Ed and the New York Times. To my left is Colleen Phillips, a trial attorney in the Educational Opportunities section of the Civil Rights Division in the DOJ, where she conducts investigations and compliance reviews and litigates cases to ensure schools are providing students with non-discriminatory education environments as required by Title IV of the Civil Rights Act of 1964, Title IX of the Educational Amendments of 1972, and Title II of the Americans with Disabilities Act and the Equal Educational Opportunity. She's got a lot of law behind her, of 1974. She's one of the staff members of the Department of Justice, or at the Department of Justice, who works with the White House Task Force to protect students from sexual assault, a task force that's been a lot in the news. And she also serves on the Sexual Assault Working Group of the Civil Rights Division. Prior to joining the DOJ, she was an assistant district attorney in the Child Abuse and Sex Crimes Bureau of the Bronx District Attorney. And she holds a JD from the University of California, Berkeley School of Law, where she was in the first class I ever taught as a law professor. So I'm kind of attached. And last is, at the end of the table here, is Jane Stapleton. She's the co-director of the University of New Hampshire Prevention's Innovation Research Center, which helps post-secondary institutions, federal, state, and local communities develop and implement model policies, procedures, and programs on issues relating to violence against women on campus. One of her current projects involves developing a bystander intervention video game to prevent sexual assault on college campuses, funded by the National Institutes of Justice. And she trains colleges, universities, and community organizations in numerous projects or techniques, including how to facilitate bringing in the bystander intervention programs and implementing comprehensive strategies to end violence. She was one of the founding members of the Sexual Harassment and Rape Prevention Program at UNH, which was only the second rape crisis center on a college campus in the United States, and has provided direct services to survivors, developed, facilitated, and evaluated prevention programs, and directed campus-wide efforts to end sexual and relationship violence at UNH. She currently serves on the board of directors for the School and College Organization for Prevention Educators, SCOPE, and has served on the board of directors of the New Hampshire Coalition Against Domestic Violence. She also teaches in the Women's Studies program and the Family Studies department at UNH. And as an activist, administrator, policymaker, service provider, and researcher, has worked in the field of ending sexual and relationship violence for 28 years. So as you can tell, we have an incredibly distinguished and experienced panel here to address some of the issues of the day. So I'm going to kick it off and start perhaps with Samantha here to my right and ask the sort of foundational question, which is why is campus sexual assault such a salient issue now? What is propelling it into the national dialogue?
So wait, do you not want us to do our...
Oh, I'm sorry. First, I'm going to let them speak for themselves, as I promised, and then I'm going to kick it off with a question. I'm jumping ahead of the queue because I'm so excited. Let me start actually with Suzanne to give a brief introduction, and we'll go down the list. Thank you.
Thanks, Erin. You actually gave a completely thorough introduction of me, so I think what I will just add is maybe 2 or 3 things. And the first has nothing really to do with the content of the panel, but a lot to do with career advice for law students, which is to say that it's very good to have direction and all of that, but it is all, the career arc of a lawyer, as you can see from many of us here, really evolves over time. And I often say when I teach civil procedure that if you told me I would have been, when I was a law student, that I would become a professor teaching civil procedure, I would have, it's hard to say it politely, but I just would have told you I didn't really think that was likely. What I also never thought it was likely that I would wind up doing any kind of higher education administration. My real interest was in doing law reform work, which is how I wound up at Lambda Legal working on LGBT and HIV-related litigation legislation and public policy advocacy. The reason I mention that is because the law reform framework that I worked in at Lambda very much guides how I think about doing work in this area. And that is, I think, I think that there are many pieces or features to changing an environment with respect to sexual assault on college campuses, right? And one certainly relates to policy. A second, though, relates to communication, right? How are policies and practices communicated? And a third, very fundamentally, relates to climate. And the way I'll relate it back to how I entered this work is that when I've done, doing gay rights work in the early 90s, right, where you always lost, or almost always lost your cases, one of the ways that was very important to thinking about succeeding and trying to change was to think about how do we change the surrounding environment, not just how do we make great arguments to courts. And likewise, on these issues, thinking about the many different ways in which each of us can step in and engage with the environment to try to bring about some transformation.
Thanks. So I work for FIRE, as Erin said, and FIRE is a student rights organization. We focus on individual rights like the right to free speech and the right to due process, and for many years, free speech work was really the bread and butter of what we do, and it still is to a large degree, but over the last 5 years, we started noticing an uptick in the number of complaints we were getting from students who were telling us about problems in university judiciaries. They were being denied due process. And that's really how we became involved in this issue. And so we don't take a position on sort of the cultural issues, which I know we're going to be talking some about today. Our position is really that, no matter what, students in university judicial systems, when they are being charged with serious, offenses like sexual assault, are entitled to due process protections, not only because it's important for people accused of a serious offense to have those due process protections, but also because, due process really ensures a reliable outcome and benefits everyone involved. So that's sort of where I'm coming from. With that, I'll pass it on to Colleen.
I'm going to start by giving you some advice for your academic career, which is if you can, take a class with Professor Murphy.
Oh. Sorry, I didn't put her up.
I wouldn't be here today without her guidance. So thank you for inviting me. I work for the Department of Justice Civil Rights Division in the Educational Opportunities section. And part of my work is Title IX enforcement and compliance work. And I promised one of your fellow law students that I would explain a little bit about that because I don't think that it's entirely clear to a lot of people. The Office of Civil Rights of the Department of Ed is the public face of doing Title IX enforcement work for the federal government, and most people think about the Department of Education. But Title IX is actually a very interesting statute that gives jurisdiction to any federal agency that gives funds to an education program. So NSF has jurisdiction, NASA has jurisdiction. However, it is the Department of Ed and the Civil Rights Division of the Department of Justice who do the most cases and work in this area, but there is dual jurisdiction among agencies, and so we do part of the work. And in addition, the Civil Rights Division has jurisdiction under Title IV of the Civil Rights Act of 1964, which gives us jurisdiction over sex-based discrimination in public schools. So part of, and most of the reason I'm up here is because the Civil Rights Division does a lot of work in this area, similar and akin to the work the Department of Education does.
Hello, everyone. I'm Jane Stapleton, and I'm the co-director of Prevention Innovations Research Center at the University of New Hampshire. And when I think about how and why I'm sitting in front of you, it actually started when I was a graduate student at the University of New Hampshire in 1986. And it was really at a time when we didn't have words like date rape and acquaintance rape and gang rape, and we didn't have the Clery Act, which maybe we'll talk about today, and we had Title IX, but our interpretation of Title IX didn't include sexual harassment and sexual assault as a form of sex discrimination. So it was a really different time, and I entered graduate school to get a PhD in sociology. And the second year I was there, 3 men sexually assaulted a woman in one of our residence halls, and she was very intoxicated. And the university held the 3 men responsible for endangering another student, and they got summer suspension. And it ignited in me really this passion to want to do something that made a difference, not only for women like the survivor who actually ended up leaving campus, but to have a greater impact both on my community and society in general. So I ended up leaving a PhD program and starting one of the first campus-based crisis centers in the United States. And I worked there both providing direct services and prevention, and then I was the director of the program and then the administrator, and then I came to what I consider the best job in the world, which is what I do now, and it's developing and evaluating prevention and response strategies to prevent sexual and relationship violence and stalking. And so while I'm the only non-lawyer on the panel, I think the perspective that I really want to share with you is that we need to keep prevention at the center of the conversation about sexual and relationship violence and stalking on campus, because as long as we just have the assumption that perpetrators will always perpetrate and we will always have victims, we just are on this hamster wheel that just keeps us going round and round. And so I've been fortunate enough to work with over 20 researchers and practitioners at Prevention Innovations, and then working with practitioners to implement our evidence-based prevention, because we do see a future where violence is, and interpersonal violence is really not many people's realities. And so I'm really excited to share that perspective with you about keeping prevention in the center of the conversation.
Wonderful. Well, I'll go back to kicking it off as I had initially thought with this new frame, which is to ask the sort of foundational question of why now. This is obviously not, sexual assault is not new. It's not something that is, just started happening on college campuses, and yet we seem to be in a moment of public consciousness about it, or legal sort of framework shifting about it. So we'll start perhaps with Samantha. Why now is this a national political conversation?
I think it's a national political conversation right now because of the work of the Office for Civil Rights. In April of 2011, following some, following allegations that a lot of universities were not doing enough to handle claims of sexual assault on campus, the Office for Civil Rights issued what's called a Dear Colleague letter, which went out to all of the universities receiving federal funds, and it contained a lot of very specific prescriptions for what universities needed to do in order to comply with Title IX with regards to sexual harassment and sexual assault. There were a few very specific prescriptions that affected FIRE's work a lot, such as mandating the use of a preponderance of the evidence standard and discouraging cross-examination. But really, it overall just, I think, propelled it into the national conversation. And around the same time that OCR issued the Dear Colleague letter, they also started to increase the number of schools that were under investigation for Title IX violations. So the first time they publicly released those numbers was in May of 2014, and there were 55 schools under investigation, and as of now, there are more than 160 schools under investigation. So right now, there is a lot of, and the ultimate sort of trump card that OCR holds is federal funds. So if you're found out of compliance, OCR can initiate action to withdraw federal funds, or maybe it's DOJ that has to actually take the action. I don't know how you guys.
Just to clarify, any agency that gives funding can withdraw the funds. So OCR can withdraw the funds that Department of Ed gives. DOJ can withdraw funds that DOJ gives. But the Department of Justice also independently can file suit in court, which is an ability that OCR does not have. Keep going.
So I think, that pressure that's on universities now, the number of schools under investigation, the fact that, OCR has made public the schools under investigation, and it's been in the media a lot, I think that's sort of really brought it to the forefront of the national conversation, at least from what I've observed.
Can I just add to that, though? Yeah. I want to add to that a huge reason that it is in the national forefront is because of student activism.
Right. I was going to say that.
It was the activists who started bringing complaints to OCR that made OCR recognize that this was an issue on campus that should be addressed. And I'm not speaking for OCR when I'm saying that. I'm just saying that there was an uptick of complaints. It is activists who've been driving the conversation. It is activists who were bringing suits in court. So this was not that an independent federal agency on its own brought this up. There was a huge groundswell of activists on campus. And if you actually follow the data of the 1 in 4 and the 1 in 5 number, that was the number that Mary Koss found back in the 1980s. And that number has been consistently coming up since the 1980s in studies after study. And there is a contested study on that, which is the Charles Krebs study, which only analyzed 2 schools. But that 1 in 5 number was then validated in 3 independent studies. Work with me, Jane. The Association of American Universities study over the summer, the Washington Post Kaiser study over the summer, and then the recent Bureau of Justice Statistics study that validated the climate survey that the White House put out. All 3 of them, which did national studies of schools. There's 12 in BJS, there was 20 in Kaiser, and they were across the board, 2-year schools, 4-year schools, just undergraduate colleges, higher universities. And while individual school victimization rates vary greatly, 1 in 8 at some schools, 1 in 2 at others, the national statistic is pretty solidly 1 in 5, and that's been true since the 80s.
So, were you about to jump in? Go ahead, Jane.
Well, I just want to confer with Colleen, because from a perspective of an advocate, I have seen really a shift in survivors and their allies and families and supporters coming forward. And I think we really saw that, early 2010, 2011. And so I think that really survivors coming forward, and then the support that they had, like very vocally, they had never before, I think really helped to propel this to the national spotlight, and their persistence in keeping it there.
And maybe I'll just add a little bit of a theoretical framework for this shift. So I don't know how many of you have studied concepts of political opportunity structure, right? The idea that there are certain moments in time where there is not only the interest in the issue, but also a galvanization around the issue that actually gets some traction. Because as others have said, that some of this data has been around for quite a long time, and as probably you've heard many of us in the sort of older group say, we were participating and thinking about and talking about these issues when we were on college campuses. So let me just identify what a couple of the factors are that I think in this, through the political opportunity structure frame, have contributed also to elevating the issue, because it's certainly elevated for some of the reasons that each of you has said as well. I think, one, we are in a time where there is increasing attention to the conditions that give rise and respond to injustice and harm. And so that is a sort of a general mood in the country, and a general framework in which people, whether they are articulating in that way or not, are thinking about a range of issues. There's been a lot of focus on inequality, right, and harms associated with that, whether it's economic inequality, racial inequality. This particular piece of inequality, I think, is fitting with some of those conversations. Second, I think when we think about communications, there has been a real jump in feminist media. I think feminist media had a lull for a while, or was sort of on a steady path. To state the obvious, the internet has made possible a new range of communication, and I think the taking off of feminist blogs and Twitter feeds and Facebook sort of forums for those kinds of conversations has been very important. I think third, there's been attention to these issues not only at the local level and even at the national level, but at the supranational level. When you think about what UN Women and the UN, for example, and other bodies have been doing to draw increasing attention to violence against women, this is part of a broader movement. So I think to look at what's happening on U.S. college campuses in isolation from some of the rest of this takes out part, is to miss part of what is sort of supporting the high level of interest in the conversation. And I think an additional piece is that at this time, there are people not only on college campuses who have been vitally important in raising the issues, but also people in government and people in higher ed administration and people in a range of, and in the media who are interested in giving attention to and working on these issues as well. Because usually when change comes about, it comes about because not only is somebody calling for attention to the issue, because people are calling for attention to issues all the time, right? And on many issues, many of us might think, well, that one deserves attention, but it's not getting a lot of the attention it deserves. And here, I think it's the confluence of these factors that has really enabled greater attention, and also greater attention in a sustained way.
I wonder if something, Colleen, you cited the 1 in 5, 1 in 4 statistics, and Jane, you mentioned, sexual assault isn't sort of inevitable, it isn't a natural feature of campus. I wonder if you would speak, maybe Colleen, you could kind of kick things off, but what is the right picture of campus sexual assault? When we use something that's a broad term like campus sexual assault, what are we imagining? What kind of incidents? Obviously we're, I think, thinking largely of either a perpetrator or a victim belonging to a community that's an educational community. But in terms of the nature of these assaults, who are we trying to speak to legally with this regime?
I don't think there is one identity to campus sexual assault, because you actually see this across the board. And you have to remember that campuses, a lot of campuses, not all, two-year community colleges and commuter colleges won't have this identity, but residential campuses where a lot of students live on campus are very much little microcosms of the community. And so a lot of attention right now is being given to sexual assault in the undergraduate sphere, and a lot of that is peer sexual assault, so peer-on-peer, student-on-student sexual assault. But that isn't all that it is in the college campuses. And there are other high-profile cases currently in the media where you're seeing substantial amount of sexual harassment happening on the graduate level and with faculty and faculty issues. So I don't think that you can say at any point that there is an identity to campus sexual assault or campus sexual harassment. I like to work in sexual harassment because there's gradations of sexual harassment, sexual assault being a more extreme one. But I think that there isn't a right identity. And when we talk about identifying it at a school, this is one of the reasons schools are encouraged to use climate surveys, because that's the only way you're going to understand if your school has a problem and what that problem is. Because while there might be an issue at one student identity or student organization on campus at one school, that might not be the issue at another. And without having a validated climate survey, you're really not going to know what the issue is at your campus.
Well, and I would say we love climate studies as well, because if we're able to really understand what the campus needs are, then we can really begin to address and build comprehensive strategies to address the needs. And so while it's currently not federally mandated, many colleges and universities are beginning to do climate studies so that they can get a better handle on what really is happening on their campus, because the national statistics oftentimes get contested. And so we really do encourage climate studies, particularly with the emphasis on how do you use climate studies to then inform your prevention and response strategies.
So I have a slightly different view of climate studies, actually. I'm not against them. I think they can be quite useful. But again, sort of thinking about them as an intervention in the environment they're not, you could say, okay, well, this climate study will give us, a report on what's happening on our campus. I actually think they can be used for more than that, and they're often more useful for more in ways other than that, because really, even with strong studies that are methodologically sound, the data is always going to be challengeable on some level, in the sense that the response rates are not typically very high, and in almost no cases are they higher than 50%. Even the AAU survey last spring that included 27, or maybe it was 28 plus Columbia, or Columbia was among the 27 universities that did that survey, the average response rate was around the low 20%, I think. So which raises questions, right? Who didn't answer? Why didn't they answer? What does it mean that they didn't answer? So but I think at the same time, the studies are very useful, because I actually think without studying, we know that non-consensual sexual contact of a variety of sorts is happening. Right, I think that we can posit that, and I actually also think we can posit that there's a fair amount of sexual harassment, that a lot of it is peer-to-peer, and that some of it involves students and others. And so to me, then, a climate survey is partly useful, because it does provide data to say, okay, now we have some documentation, even if there are questions around the margins about exactly what the percentages are, that this is going on, and it can be a prompt in various environments to help start to take steps to address what's happening. I just want to also try to respond a little bit to your question, Erin. What does the picture look like? And really echo something Colleen said, which is that the media has focused a lot on what this is like for undergraduates, and in particular for undergraduate women, and in particular for undergraduate women in their first 2 years of college. And that is certainly a high-risk, highly vulnerable group in higher ed populations. As everybody here knows, it's not the only vulnerable group. And as everybody here knows, I assume most of you are in law school, right? These are not issues that are isolated to undergraduates. These are issues that concern graduate students as well. They're issues that are in the world, right? Why would they, there's no barrier between higher ed and the rest of the world that would suggest that the kind of sexual violence and sexual harassment that takes place in workplaces, including legal workplaces, and on the street, wouldn't also take place in our own environments, even though we might like to think it wouldn't. So I want to really underscore that the picture is quite varied, and of course, in media communications, there will be some iconic stories that then become to stand in for what people might think is all of what's going on, and that's really so, as I think everybody in this room should know, rarely, if ever, the case that the one story illustrates all of the complexity of the situation.
So I think one of the challenges with that, if I can just jump in, and some of you may have recently seen some of the documentaries that are out, like The Hunting Ground, and so I think one of the unfortunate, there's sort of both sides to the coin there on films like that, because they highlight extremely egregious cases, very traumatic on multiple levels. And I think sometimes what we hear from survivors is they look at films or the high-profile cases, and they look to their own experiences, not only in what they experienced, but how they chose to deal with their own cases, and they look at them and they say, well, mine wasn't that bad, or... So I think we do need a broader understanding of the complexities of sexual assault on campus. But with that said, we also know, particularly for undergraduate, traditional age college students, that they have risk factors that oftentimes populations outside of college don't. So I think we just need to acknowledge that.
Yeah, although just on that quick little point, sorry, just one more thing. The data for the same age population in the world, students, people who are of college age but not on college campuses, shows, this is Department of Justice statistics, right? Yep. So maybe you should talk about those DOJ statistics,
yes,
but where the sort of rates of sexual violence toward women who are college age but not in college are either similar to or higher than those for women in college. So, I think sometimes this gets reported as though being in college is a special risk factor. And I think sometimes because of the nature of residential life and the lack of intergenerational living, it can be. But I think to understand it only in that way actually skews the picture a little bit. And I wasn't saying that Jane was skewing the picture. I was just saying that some of the conversation publicly winds up skewing the picture a bit.
Right.
So given that we have this kind of complicated picture of what sexual assault is, I'd like to start thinking about the response that campuses take to these issues. And, you know, I could put it into sort of some archetypal frames, like a harassment issue, like a peer-to-peer harassment issue, or a faculty-to-student harassment issue, or, you know, all the way through a violent sexual assault that occurs. But I wonder, maybe Samantha, you could kick it off talking about how, you know, educational institutions are responding and what might be positive and negative aspects of that response.
Okay, so I think that, I mean, the way that educational institutions are responding is in large part informed by Title IX. So, you know, I can talk about what I think the ideal way would be to respond, but, you know, we have to recognize in talking about how they should respond that right now they have to adjudicate these claims under Title IX. I mean, you know, when I talk to people outside of the law and outside of higher ed about what I do in my research, a lot of times what they say is, well, wait, why are campuses, why are university judiciaries trying people for sexual assault? Isn't that a matter for the police? And, you know, it comes back to Title IX and the fact that because sexual assault is a form of sex discrimination prohibited by Title IX, campuses have to be able to adjudicate these claims. So, you know, given that that's the framework we are in, I think, you know, it's best to talk about what I think the best practices are within that framework. I think that universities are very well positioned to provide support services to people, to victims of sexual assault, you know, whether that be counseling, whether it be accommodations in terms of changing dormitories, and that can be changing the dormitory of the accuser or the accused. I mean, where FIRE's concerns about due process really come in are not with those kinds of measures, which, while they might be, I mean, it might be, you know, burdensome to someone to say, listen, this person has accused you of assault and we're going to ask you to switch your class schedule. FIRE's real concern is in the adjudications of guilt or innocence, and how those are being handled. And, you know, what we have seen is that in an effort to comply with Title IX, a lot of universities have gone far above and beyond what Title IX actually requires and have implemented procedures that oftentimes don't contain adequate due process protections for accused students. And when I say that, I mean not having a hearing, you know, using somebody as a single investigator who investigates the claim, maybe interviews the parties, and finds responsibility without holding a hearing or giving an accused student the opportunity to confront, even indirectly, his or her accuser. You know, there are oftentimes concerns about notice, particularly with regard to the specificity of the accusation. So we see students called in for meetings to say, okay, you've been accused of sexual misconduct, and interviewed without being given details of the specific allegations against them. You know, things like that. So I think that what we see is that, you know, universities, I think, can and should be providing support services to victims. I think where we see real concerns right now is in the adjudication of guilt or innocence, and that's where we've been advocating for, you know, more protections for, more due process protections for accused students.
What kind of can you speak a minute about what you would imagine then within?
Sure. I mean, when I think about due process, I think about obviously notice. I think some kind of hearing is essential. You know, it doesn't necessarily have to be a full dress hearing, but I think having having a system where roles are commingled so that you have an investigator who's doing the fact finding and adjudicating responsibility, and in some cases hearing the appeal, is troubling. I think the right to have an advisor and have that advisor meaningfully participate in proceedings. You know, I think there's a real challenge when you have 18 and 19-year-olds defending themselves against accusations of sexual misconduct, oftentimes without an ability to even question the person accusing them. I think some sort of meaningful right of cross-examination. I don't think it has to be direct. That is to say, I don't think that, you know, somebody who is accusing someone of sexual assault has to then be questioned by that person. But, and again, this goes back to the importance of perhaps allowing an advisor to participate, the ability to question through a third party and to meaningfully question. A lot of universities have allowed questioning when there is a hearing, allow questioning through a hearing panel, but the panel will often have a complete discretion to modify or exclude questions. So I think those, you know, the notice and some sort of hearing, some sort of meaningful right of cross-examination, not necessarily directly, and meaningful participation of an advisor, I think those three things, if I were to pick three, would go a long way towards, I think, ensuring the fairness of the process.
I think the Department of Justice feels the same way, that the investigation and adjudication process, Title IX says this, has to be prompt, but it must be reliable and it must be impartial. That means that both students have to be given the opportunity to present witnesses and evidence and provide meaningful ability to present their case. And there has to be set procedures in place to ensure that the process is reliable and isn't impartial. And that is even just giving the sense of impartiality so that individuals going through the process don't say, but it's unfair because of X. And so schools need to be really considering when they set up their process, do we have the checks and balances in place? Do we have the oversight in place that's ensuring that there isn't even a sense of impartiality on how this is happening? Are we effectively communicating the process? Are we effectively explaining the process? Are we effectively explaining our findings so that they are reliable and impartial, that it meets the requirements? If there's not a sense that the adjudication process has these checks and balances and this oversight, then there won't be faith in the system, which will be chilling on all levels. You have to come back to the purpose of Title IX, and also from my perspective, Title IV, which is, this is about access to educational opportunities. It's about kids getting to go to school and learn. Sorry, I shouldn't say kids, I'm in a law school. But Title IX and Title IV cover K through 12 and institutions of higher education. So kids down there. And on the institution of higher education level, you guys worked really, really hard to get here. And you should have the opportunity to stay in school. And that's why it is so important that there be strong, set processes, really strong, reliable procedures, and training of the individuals who are conducting these procedures so that we know that they're done fairly, and we know that they're done well. And that's a necessity.
Can I ask a quick question? Because I heard in your intro that you work with the task force to protect students from sexual assault. The White House Task Force?
Yeah.
So one of the things, so when the White House Task Force to protect students from sexual assault issued its first report in, I think, 2014. And in there, they spoke somewhat favorably about this investigatory model that I mentioned, where you don't have a hearing, you have, a single investigator or, several people who are conducting the investigation, finding responsibility. And after that, we saw a lot of universities move towards that. And I don't know if that's because they kind of saw it as the writing on the wall in terms of where the federal guidance was going, but I was just curious, if you had any sense, if you're working on it, on where that's going, if that is sort of the direction the federal government is headed in terms of its recommendations?
The federal government does not require, and currently neither does court law, any set type of investigatory or adjudication process. And that's for the reason that there are between 6,000 and 7,000 colleges and universities here with very different identities. And what might work at a 4-year undergraduate university with a graduate program is not going to be an effective process at a 2-year community college. There has to be the leeway to schools to provide the procedures and the processes that is effective for their student body. So there is no requirement that there be any type of investigatory or adjudication process. When the White House Task Force was released, it identified that there had been a move by some of the campuses towards this single investigator. There are quite a few campuses that still use hearing boards, and there's quite a few campuses that use kind of an amalgamation. It's called a hybrid model, which is an investigator does the investigation, but then another person or maybe a panel actually does the hearing and the final decision making, regardless of which choice a school makes. And Title IX does not require anything. The school gets to make that. What these have to be is set, well-established policies that have to be published. Title IX says your grievance procedures have to be published, but the training for the individuals who take part in the investigations and the adjudications has to be strong so that it's reliable. And that's all that's required.
Suzanne,
Yes.
you want to weigh in?
Yeah, sure. And actually, I do agree with much of what has been said, not all, but I wanted to start by focusing on the question, meaning what is the question that these adjudication processes are designed to answer? Sorry. And the question is a student A responsible for violating the school's policy that prohibits let's just say in this circumstance, non-consensual sexual contact, right? So the determination, first of all, is whether the student is responsible, right? It's not a guilt or innocence question. It's not the same as the criminal process. And then if there's a finding of responsibility, there's a sanctioning process that flows from that. Most people here are law students, right? So you've taken civil procedure at this point, and I'm hoping you had a long time of conversation about due process, right? So you know due process is about a meaningful opportunity to be heard, and actually when you look back at the early civil side due process cases, starting with Goldberg versus Kelly, moving on to Matthews versus Eldridge, and more recently, the through line in those cases is that when we talk about meaningful opportunity to be heard, the court is going to look at, well, what is meaningful in this circumstance, right? So that's similar to what both Samantha and Colleen have been saying, right? What are the elements we need to have a fair process that gives the person who might suffer some deprivation a meaningful opportunity to contest the charges against them? And that does have elements like notice. A person has to know. What have they been charged with, accused of? What policy have they been accused of violating? What's the nature of the argument or the evidence against them? And that all seems quite appropriate. Now, but what those cases also say is then you need a process that's tailored. And given the wide variety of schools, it makes sense that Title IX doesn't say what kind of process there must be. But certainly there must be a process. And I just want to add a note here that I think is important. Even in the absence of Title IX, right, schools would and should quite reasonably have a policy that forbids students from not engaging in non-consensual sexual contact with one another. So although Title IX is the governing law here, it's not all that's here, right? Higher ed institutions have a range of policies that govern all of your conduct, and the reason they do that is because there's a set of community values that gets translated into policies that are to shape the way in which people, or certainly set the aspirations for the ways in which people in a community relate to one another. Now, how to do that fairly, I think there are different structures that can work. It does seem quite clear that in addition to notice, part of the meaningful opportunity to be heard is to be able to challenge the evidence that is against you. Now, what does that require? I think it's not actually, in these circumstances, I think it's useful not to approach it in a formalistic way like we lawyers sometimes do, and instead to think about, well, what does that mean, right? How can somebody meaningfully raise questions about what they've been accused of doing? And how can a process be designed that is fair and sensitive, fair to both students and sensitive to the issues? Because after all, keep in mind that any school administering one of these processes, when there's a dispute or a charge from one student against another, is handling a charge that involves both of its students, right? These students are both members of the university community, and that is another reason for the motivation of fairness. It's certainly Title IX, and it goes beyond that.
Can
I think just the last, sure, go ahead.
Can you say a word about what you would envision as an opportunity to challenge that wouldn't be a kind of traditional, formal, legal, what we've constructed through sort of
a standard
criminal
cross-examination?
model?
Yeah, I think there's a lot, but I think a useful model in these circumstances is one along the lines of what you mentioned, which is that a student should be able to identify the set of questions that they have regarding the evidence against them, and that that whoever is handling the process, whether it's an investigator or a hearing panelist, have the responsibility to find ways to communicate those questions. But like even in a court process, a lawyer for a defendant doesn't get to cross-examine without limits, right? There is always an opportunity for the lawyer for, say, the state in those cases or either lawyers on either sides to object to lines of questioning.
So
if you deformalize that, what that means is all of this requires judgment on the part of hearing panelists or investigators or whoever is running the process, and I don't think we should, and I think it's, I guess the last thing I'll say, just to and then turn it over to others, is that is why the training that I think both of you have mentioned is so critical, and really, to me, the sort of formal structure of the process, matters. I'm a civil procedure person. I'm not going to say it doesn't matter at all, but what will really be most important in terms of fairness to both parties and sensitivity given the context is very effective training in exactly the sorts of things we're talking about of the people who are participating in all aspects of the process.
I also think that you have to consider the position of the students and make sure they understand explicitly what the process is. Because if you're a student saying, I want these questions to be asked, X, Y, and Z, and a hearing panel or investigator or a student conduct officer says, no, we're not going to ask those questions, imagine how you would feel. So there should be upfront information conveyed. These are the type of questions that we don't allow. These are the type of questions that we do. They should have an understanding, and I say they because students on both sides equitably should have an understanding of what the process is, what information is allowed, what isn't, why it isn't allowed, things like this. There should be upfront information conveyed to the students who are a part of the process so that the process itself doesn't impede educational opportunities. So the process itself doesn't end up exacerbating harassment or something like that.
Well, here's why it's important. This is in an educational setting, right? So it's both, here's in advance what you ought to know, and here's why we're not going to ask that question in the way you've put it, right? That's not something a judge is going to do in a criminal case. I mean, they may give a one-word explanation, or they may not. They're the judge. This is a different setting. And again, the question at the end of the day is, has an accused student violated a policy of the university? So the university, I think, does, or the college does, have an obligation to do explaining and educating around the process.
And I was just going to say, I think this really speaks to the need for both advisors or advocates on both sides.
I was going to say that.
And particularly from a survivor perspective, the importance of a process as well as advisors that have been trained in trauma-informed support is really important, because I think one of the motivations behind the Dear Colleague letter was to also ensure that the processes on the college campuses were not re-victimizing to victims, which unfortunately has, I think, been the experience both on college campuses and in the criminal justice system. David Lisak, who's a researcher who's looked at perpetration, I heard him say this once, and I thought it was really interesting. He said, I think one of the reasons why college campuses have the responsibility to adjudicate campus sexual assault is because the criminal justice system has so oftentimes failed victims. And I think the point that Suzanne just made about the opportunity that educational institutions have to also provide education through the process is really important. That's not always, the opportunity is not always there in the criminal justice system. So I think the role of advisors, particularly with a trauma-informed lens, is really important.
So maybe I'll just throw one more question out, and then we'll open it to the audience. And I was actually going to start with you, Jane, although anyone can weigh in, which is, I think one thing that campuses often say is they're caught between this kind of rock and a hard place. If they don't, have systems in place to ensure compliance with Title IX, they can get sued or they can get investigated by the government. If they, put what they think of as rigorous protections in place, then they get sued by accused who say you're not properly abiding by my due process rights. And so they are caught between those two poles of, getting sued from somebody. So I wonder if you could speak, I was going to turn it to you, Jane, initially to say what you would like to say about what kind of other ways campuses can respond to this problem, if the legal framework is the right framework to be thinking in, if Title IX is the sort of right way to be addressing campus sexual assault, and then maybe other panelists also can chime in about that quandary or about the role of the law here.
Mm-hmm. So we actually oftentimes think about the response to campus sexual assault as being a pie with three big parts. So one of them clearly is response to survivors. One of them is certainly providing due process for those that have been accused. And another really important part is prevention. So we do believe that prevention belongs in that conversation. And right now, colleges and universities are required to do certain types of prevention or education with their incoming students, their first responders, and now all employees faculty, staff, or students of the institution are mandated reporters. Now, that's being interpreted differently on different campuses, and I don't know if anybody on the panel can speak to that, but colleges and universities are actually required to do education and prevention as part of the mandates. And all of the colleges and universities that I work with literally are one phone call away from being on the Title IX list. And so what they oftentimes do, particularly around prevention and education, is they go and they seek to check the box of mandatory prevention. And unfortunately, a lot of times they're sort of choosing, whatever comes to them first. And it oftentimes is not evidence-based or research-informed. And so I think the approach that Prevention Innovations Research Center takes, particularly in developing our research, but also in working with institutions, is to really ask them to move beyond checking the box, because checking the box isn't going to stop campus sexual assault. So it's about developing evidence-based prevention that engages the entire community. And I think oftentimes colleges and universities see this problem as only an undergraduate college students' problem, and so the education is focused only on the undergraduate students, and unfortunately it's oftentimes only focused on the first-year students. So what we know about prevention is that oftentimes this one-step approach, or this program in a box that happens the first 24 hours you're on campus, the longevity or the effectiveness of those programs is very limited. So we really need to work with campuses to build comprehensive prevention that lasts throughout a college student's career, whether or not it's undergraduate or graduate, and it needs to engage faculty members, staff members, college students, local businesses, friends and family, if they're traditional age college students. So we have the opportunity to take advantage of the mandates that require prevention, but to really think about it in a very comprehensive way. And so it's in that vein that we really see that prevention needs to be part of the conversation. And right now, colleges and universities are mandated, but they are just sort of checking the box. So we're trying to move them beyond just checking the box.
I'll just say quickly, one of the, I think, Jane and the Prevention Innovation Center is one of the few places in the country that is has a long-standing effort to do serious evidence-based work. When you look at the studies around sort of the academic studies that look at, well, what is effective prevention education, there's very little that has proven to make a difference, which isn't to say stop, it is to say there are many different types of efforts that can be tried. I mean, we know some of the things, right, that anybody of any of you, even not having read the studies, could say. And I always ask people this, right? Think about the trainings that you have been to. And if you can stifle a yawn just for the moment and indulge me, right, try to think about, well, what has stuck, right? What makes a difference? To me, that's a good guide to, well, what might be useful to put into a training. Usually that's a small group conversation led by a really skilled facilitator. That can be a very hard thing to implement on a massive campus, especially when the world is not overflowing with really wonderfully skilled facilitators in these issues. And I actually encourage you, if that's an interest of yours, even if it's not your main career goal, it's something that you might consider developing while you're here. I'll just share with you one thing that we're doing at Columbia. I have a very strong view that for students, as Jane was just saying, to get their prevention education only in orientation is not super useful. I've certainly spoken at a lot of law school orientations, and I know what everybody's sitting in the audience thinking about while I'm talking. It's, am I going to find anybody to have lunch with, right? And how am I going to manage what this is going to be like? They're not necessarily fully absorbed. They might, when I'm talking about academic work, they might really be listening, but otherwise, there's a lot of tracks going on for people. So when do you do it and how do you do it? I think certainly pre-arrival is a good time. Something at orientation. We also have a program we created last year called the Sexual Respect and Community Citizenship Initiative that requires students to participate during the semester. There's a lot of the theory, pedagogical theory is a lot of free choice. Students can choose workshops, film screenings, online options. There's a special option that's geared for survivors and other people interested in trauma, and an independent projects option. If you Google sexual respect in Columbia, you can find a little bit about it. But the idea is, again, how do you have work that's ongoing through, or engagement ongoing throughout the academic year? Because when we're talking about climate change, and this is something that gets back to what I said at the outset, it's not a one-shot activity, right? And even interventions like these, are one-shot in certain ways, so they're limited. But how do you do this climate change work in environments where students are incredibly busy? I mean, I assume you're busy here at NYU like students are at Columbia. But where students are, that was a joke. Where students are incredibly busy and overwhelmed doing their work, doing their student activities, doing whatever they might be doing, having their lives. How do you involve this and engage people in a meaningful way and in an ongoing way? And I think it's a wonderful opportunity and an interesting challenge for all of us. And it's clearly something that requires the engagement of students. So as much as students also are engaging in activism to call attention to the adjudication process and the disciplinary process, I would love to see more students getting really involved in how do we do this part of it, right? How do we really get active on the prevention work in a way that engages all of us?
And I think one of the reasons why we're not there yet is because it's really hard work. I mean, we're really talking about culture change. It's about shifting, and again, not only for students, it's for faculty, staff, administrators too. How do we shift our whole orientation of how we interact with one another? And I think it is, in some ways, it's uncharted territory. And so we are really just beginning to take baby steps, but we need to take those baby steps so we can take those bigger steps.
So maybe this is a good time to open it up to you all for questions. I think there's a microphone floating around.
I'm happy to stand. Hi. I have a question about, so the word microcosm was used, which is a great word for those kind of residential campuses, and there are tons of them, and sometimes there are like 30 to 40,000 students who only think of themselves as students at the university and not as residents of a county, but they're all in counties that have law enforcement agencies. Mm-hmm. So Berkeley and Alameda County and Michigan and Washtenaw County. And how do you see the relationship of law enforcement to campus investigation and adjudication? If there should be a relationship, if the university should, separate even further than they currently are, how to, what it should look like between the two.
Well, as a general matter, I think that there definitely needs to be a relationship. I mean, because, law enforcement has power to collect evidence and things that campus adjudicators don't. For instance, there was one case where it was an allegation against a student. The students had videotaped a non-consensual sexual encounter and then deleted it from their phones. And so there was not only the deleted video from their phones, but there were also searches, which also they tried to wipe everything, Google searches on can police recover deleted searches. And so, because in that instance, the university turned the search over to law enforcement was able to recover that data, whereas the university wouldn't have been able to. Because, it's important to remember that although we're looking at these things on campus through the framework of Title IX, sexual assault is a crime. And, law enforcement, while obviously law enforcement, particularly in certain parts of the country, has had a flawed track record with regard to handling these cases, they do have a lot of procedures and then also in some cases protections for both parties that colleges and universities can't offer. So while I don't have a specific prescription for what a memorandum of understanding should look like between a campus and local law enforcement, I do think that having some kind of memorandum of understanding is important. Because it's also important, there are cases, and this can cut both ways too, things that an accused student, who again often is not allowed to have a representative, says in a campus investigation may later be admissible in a criminal proceeding. But we also just recently got a complaint or a question from the father of a student who, the father of a student victim, who was asking what he could do because the statements, the local police were saying that, the confession that the perpetrator had given in a campus investigation wasn't admissible because the person hadn't been Mirandized. So, it's very important, because these things can cut both ways. I think it's very important to have some kind of memorandum of understanding between the two parties investigating.
Do you think it should
the
be
crime.
compulsory? That just the same way as a faculty member might be a mandatory reporter to the administration, that the administration be a mandatory reporter to police?
I don't think it can be without interfering with the victim's autonomy. I mean, I think that there are ways to encourage it, but I don't think, I mean, maybe you guys can jump in, but I don't think, victims are allowed to not report, violations to law enforcement.
But there's, like, for instance, domestic violence mandatory reporting law,
Right.
or child, there are laws that say, for instance, if, I as an educator had reason to believe violence had committed against a child, I have an obligation, it's a legal obligation to report that to the law enforcement authority,
that-
not just my institution.
That's because they're a minor,
Yeah,
right?
that's
No,
because they
I
don't
know,
have
but
autonomy.
whether we could basically imagine, say, a Dear Colleague letter that comes down and says, it's not enough that the institution's doing something, we want to make sure law enforcement is involved for those very same
But
reasons.
then people would stop reporting it to institutions. I think that
Yeah.
one
Yeah.
way to look at it, one model that, some have advocated is that, before taking any sort of adjudicatory actions, that the university could say, if you want us to actually adjudicate this, we need to refer it to law enforcement as well, but if all you're looking for is support measures, we don't need to report it to law enforcement. So that's one potential way of handling it, but I don't think you can just have an absolute across-the-board mandatory reporting without interfering with victim autonomy.
It's interesting because on the one hand, that approach sounds reasonable in so many ways. It's also quite complicated because it would be unusual to say to a student, we're not going to enforce our policy unless you report this also to the police. So or give us permission to report to the police. So which is just to echo your point that this ripples out in so many ways. And I think the discussion often enters as though issues, and I'm not saying, I don't think this was what you were saying at all, but it enters as though these were issues in a vacuum. And just to even broaden the frame a little bit here, all higher ed institutions have relationships with law enforcement where they are located on a very wide range of issues. Just to take two examples, right? Drugs and underage drinking are obvious issues where law enforcement might interact with college campuses, but there's all sorts of non-sexual assault that happens, and then there are many other ways in which people might or potentially violate criminal laws that occur in the jurisdiction of a college or university campus. So sometimes this gets talked about as though the two, that it's only about sexual assault. And I just want to reinforce, again, there's greater breadth here, and also reinforce, as people are probably well aware, right, law enforcement personnel and the approaches of law enforcement leadership differ quite widely in different jurisdictions, both across the country and even in, say, New York City, in precincts. So different schools may have different relationships with law enforcement depending on who's running a precinct, which also changes over time. So really the bottom line point is it's quite dynamic and complex. And as you think about your position on these things, it's useful to keep the on-the-ground pieces of this in mind as well.
Can I ask a
federal government-
question? Oh, sorry.
I was just saying, the federal government actually encourages the MOUs, and the White House Task Force produced a model MOU between law enforcement agencies and schools. They also produced a model MOU between rape crisis centers in the community and schools, because you were saying that schools are well positioned to provide supports and services, and a lot of schools do not have the resources to provide supports and services. So maybe they can change your housing or maybe they can change a course, but many survivors need therapy or some sort of counseling, and schools don't have it. So there are model MOUs that were produced to help schools to negotiate those relationships so they can provide the services, because well-funded institutions can provide them, but many do not have the resources to provide those supports and services.
I wanted to ask Colleen Phillips, just to follow up on your discussion of impartiality and reliability and promptness as general ideal goals. When you think empirically about the structure of liability that universities are operating in, and I don't mean that in any normative sense, but just really empirically, I'm wondering, can schools be impartial? And following that up, what do you think about the model that Harvard has proposed?
I have not conducted an investigation at and will not discuss Harvard's model for that reason. However, I will talk about impartiality, and the answer is quite simply yes. I mean, if we want to get really empirically, then can states be impartial? Can the federal government be impartial? Can my mom be impartial? I mean, you have to set up the processes and procedures to be impartial, because that is the only way you are protecting your students to ensure educational opportunities. What that means is that you have to set up responses, whether it's a confidential advocacy center is your choice, whether it's an investigatory model with a single investigator, hybrid investigator, or hearing board, that are well trained and are not put under pressure from other administrative offices on campus. You have to think about things like, is the person making the decision on this adjudication also hearing the appeal? Is that something that is going to give the sense of impartiality? Because how do you review your own decision? And there are so many ways of putting that, those checks and balances into place, and that's what schools need to be doing. But for anyone who says that, oh, they can't do that because they don't want their name to be maligned in the media, or they're worried about losing donors, I believe firmly that schools can rise above that and put in the policies and procedures that need to be there.
You know, I guess
agree.
I have a concern that, though, that the pressure from OCR puts a thumb on that scale, in the sense that, you know, I'm concerned that a school, for example, that's under OCR investigation might have a more difficult time being impartial, particularly when, you know, if, as so many schools do, the school's using a single investigator model. The investigator is someone paid by a university, which is under OCR investigation and has a strong interest in retaining its federal funds. You know, I have concerns about, you know, I would like to think that universities could rise above it, but I do have concerns about it, and some of the cases that we've seen, I think, sort of underscore those concerns.
This young man right here.
So this is for anyone on the panel, but I was curious how far you think schools can lower or shift the burden of proof. For example, if a school said, because more than 95% of survivors are telling the truth, we're going to put the burden of proof on the accused to show by a preponderance of the evidence that the encounter was consensual. Would that be permitted?
I'll just quickly say I don't think so, no. I mean, and I think the reason I wanted to answer the question is I want to bring up an important point, and one of the things I didn't mention was the trainings, and I think, you know, when we're talking about due process, I think the trainings being impartial and not, you know, a lot of times we'll see schools using materials to train hearing panels that are intended for victims advocates and things like that, and I think, you know, you wouldn't instruct, if a jury was instructed that, you know, 95% of victims were telling the truth, that would be a prejudicial instruction, because the jury or the hearing panel's charge is really to adjudicate the case in front of it. So you can't bring in those kinds of outside numbers without, you know, without, I think, impermissibly biasing a hearing panel. I mean, you have to, regardless of the statistics about, you know, false accusations and things like that, each case has to be adjudicated on its own merits.
Yeah, and I think that is part of, part of due process is having fair adjudicators and fair investigators, and part of the way you get to fair investigators is teaching people how to evaluate the evidence in front of them. On the question, well, what should the standard, the burden of proof be, which is, you know, in some circles, a very hotly debated question, right? Should it be, you know, is there a preponderance of evidence to is there a preponderance of evidence to show that the respondent, the accused student, is responsible for the policy violation? That is the standard right now that has been sort of embraced by OCR. Some would say, well, no, the burden of proof should be higher, right? Should be beyond a reasonable doubt, more like the criminal structure. And then you're suggesting even a different burden of proof. Should it be sort of even easier to hold, as I understood your question, to hold an accused student accountable? I think here's what I'd say, right? This is not, as we know, it's not a criminal process. It's a school processing. It's policy handling an accusation of policy violation. criminal law doesn't, to me, seem like the right analogy here. The civil standard of proof in most cases, including discrimination cases, is preponderance of the evidence, which if you were going to look again to an analogous situation, at least to me, seems to make a lot of sense. I actually, though, and this is a personal view, it's not an institutional view, is that I think what really matters most in these cases is less the burden of proof. Maybe this is a heretical thing to say with a criminal law scholar on the panel, but instead having good investigators and having good decision makers, because that's the key, right? At the end, we're trying to figure out, and I don't do this directly, but the decision makers are trying to figure out, is there enough evidence to show that this person violated the policy? And unlike in the criminal system, you know, this just, you know, well, let me not say unlike in the criminal system, you know, that's the evaluation, right? Let me listen to both sides, let me listen to the witnesses, let me look at whatever exhibits, documents, and other things there are, and make that determination. It can be informed by burden of proof, but that's not the biggest picture question for me.
I actually agree with that in many ways. If you have undertrained or ineffectively trained investigators who fail to collect really important information, it doesn't matter what your standard is, because the outcome is going to come out wrong on either side. And so having adequate training is really what protects the rights of both the complainant and the respondent. Because if you don't have investigators doing an adequate investigation, people aren't really assessing the case for what it is.
So unfortunately, we are out of time. And speaking of criminal law, I have to go teach it. So thank you. Please join me in thanking our panel. A very wonderful discussion.